Hello and welcome to the Womxn Show. I'm Lenina Rasool and today we are speaking about the issue of consent in rape cases. Now we are going to be focusing on a specific case that started out as a rape conviction in the Eastern Cape Regional Court. It was then successfully appealed in the High Court and has just made it through a third round in the Supreme Court of Appeal. I know it sounds complicated, but after the break we will be joined by the Women's Legal Center, who is going to explain everything and take us through that. But before we have that conversation, we're going to look at a short video explaining the issue of consent using a cup of tea. Let's have a look.
If you're still struggling with consent, just imagine instead of initiating sex, you're making them a cup of tea. You say, "Hey, would you like a cup of tea?" And they go, "Oh my God, fuck yes, I would fucking love a cup of tea, thank you." Then you know they want a cup of tea. If you say, "Hey, would you like a cup of tea?" And they're like, I'm not really sure. Then you could make them a cup of tea, or not, but be aware they might not drink it. And if they don't drink it, then, and this is the important part, don't make them drink it. Just because you made it doesn't mean you are entitled to watch them drink it. And if they say no thank you, then don't make them tea. At all. Just don't make them tea. Don't make them drink tea. Don't get annoyed at them for not wanting tea. They just don't want tea, okay? They might say, "Yes, please. That's kind of you." And then when the tea arrives, they actually don't want the tea at all. Sure, that's kind of annoying as you've gone to all the effort of making the tea, but they remain under no obligation to drink the tea. They did want tea, now they don't. Some people change their mind in the time that it takes to boil the kettle, brew the tea, and add the milk. And it's okay for people to change their mind. And you are still not entitled to watch them drink it. And if they're unconscious, don't make them tea. Unconscious people don't want tea. And they can't answer the question, "Do you want tea?" because they're unconscious. Okay, maybe they were conscious when you asked them if they wanted tea. And they said yes. But in the time it took you to boil the kettle, brew the tea, and add the milk, they are now unconscious. You should just put the tea down. Make sure the unconscious person is safe. And this is the important part again. Don't make them drink the tea. They said yes then, sure, but unconscious people don't want tea. If someone said yes to tea, started drinking it, and then passed out before they'd finished it, don't keep on pouring it down their throat. Take the tea away. Make sure they're safe, because unconscious people don't want tea. Trust me on this. If someone said yes to tea around your house last Saturday, that doesn't mean they want you to make them tea all the time. They don't want you to come around to their place unexpectedly and make them tea and force them to drink it going, "But you wanted tea last week." Or to wake up to find you pouring tea down their throat going, "But you wanted tea last night." But if you can understand how completely ludicrous it is to force people to have tea when they don't want tea, and you're able to understand when people don't want tea, then how hard is it to understand it when it comes to sex? Whether it's tea or sex, consent is everything. And on that note, I'm going to go make myself a cup of tea.
That was a short video explaining the issue of consent using a cup of tea. We are going to take a short break, but we'll be back with more after this. Welcome back to Still Watching the Womxn Show, and as you saw before the break, we are speaking about consent today, and we are speaking about rape. And we were playing that video because there has been a recent case in South Africa that reached the Supreme Court of Appeal that looked at the interpretation of consent. And so with us here in studio to explain a lot about the case with us, because it's quite complicated. It's been through three courts to get to, it's been through three courts, the Magistrates Court, the High Court, and now the Supreme Court of Appeal. With us in studio, we have back with us Andrea Joy Junchis, who is a junior associate at the Women's Legal Center, and Bronwyn Piddy, an advocate at the Women's Legal Center, to explain all of this to us. Welcome, and thank you for joining us.
Thank you for having us. Thanks for having us.
So, as I said, it's quite complicated. We've got three courts. It's just concluded in the Supreme Court of Appeal, and I was hoping that to start with, you could just run through what actually happened here.
So you're right. So it is quite a long journey where these cases have been through 3 different courts. So it started in the regional court in the Eastern Cape, where a man by the name of Liso Toko was accused by his girlfriend of raping her. And the important matter really is that the 2 of them were in a consensual, intimate, romantic relationship. And that's actually how their relationship was described to the court. But they hadn't known each other for very long. They were just really in the beginnings of their relationship. And just so we get the terminology right, I will refer to the accused, who was Mr. Toko, and the complainant, who is the rape victim survivor, because their status kind of changes, as it were, as the cases go into the next courts on appeal. So the important aspect of this matter was that the complainant was very clear with the accused that she did not want to have sex. She was not ready. She felt that she wanted to explore the relationship to see where it went, but she made it very clear to him that she did not want to have sex with him. And he accepted that. It was a kind of spoken about, overt discussion that they had. And then, as briefly as I can, what happened on the night in question was they got together with the understanding that she was going to spend the night at his house. They were going to watch some videos, but that again there was a clarification between the 2 of them that they were not going to have sex. That's not to say that they hadn't been engaging in some kind of intimate sexual activities, but very clearly there was an assurance from both sides that they would not be having sex. While they were watching videos, they were cuddling, and they started getting into some quite heavy petting. And at some stage, the accused removed the complainant's pajama pants. And at that stage, she immediately closed her legs and indicated to him again that she did not want to have sex. And he gave her the absolute assurance he was not wanting to have sex with her. He said, that's absolutely understandable. He then proceeded to perform oral sex on her, which when she testified, she said she wasn't that comfortable with, but she did concede that she did go with it. She didn't make it clear in any way that she was not consenting to that. And again, was reassured by him that he did not want to have sex with her, penetrative vaginal sex. And he then stopped performing oral sex on her and started kissing her again. And suddenly she found him penetrating her vaginally. And she immediately tried to push him away, said to him, stop, and basically said, you're hurting me. And on that basis, on those facts that were placed before the regional court, he was convicted of raping her. The magistrate in that matter found that the state had proved its case beyond reasonable doubt, that he had had sex with her without her consent. And maybe this is a good time to hand over to Andrea Joy, just to talk about what the actual definition of rape is. So we believe at that stage, the regional court, which is what we call the trial court, which is actually the best court situated to make determinations around what rape is, we believe that was the right decision. But I think it might be quite useful just to look at the various elements of rape before we then see what happened next.
I think that would be great, because Andrea, I just want to clarify here that, we have, in society, and I say this as a woman that's sort of been brought up, there's sort of a conditioning or expectation that women are going to play hard to get.
Yes.
That we're supposed to say no, right? And then be convinced to have sex. And so this creates such a lot of controversy outside socially in society about what actually is consent. So, but I think what I want to bring home is that actually it's codified in law, right? There is legislation written down about what is consent. So can you tell us?
So the Sexual Offences Act actually says that someone can be guilty and have committed rape if the person had unlawfully, unintentionally sexually penetrated another person without their consent. So that is the definition. So you have these elements. You have intentionally and unlawfully penetrated the person without their consent. And those are the two elements of rape. The nature of the consent, which is really, is it express consent, tacit or implied consent, and then also unlawfulness and intentionality, right? So did the person intend, and it's very legal, it's a very legal term, but ultimately those are the elements of rape. And if you look at intention and unlawfulness, you look at fault, right? So did the person intend to do that? And when we look at that, we really look at what we call dolus directus, dolus indirectus, and dolus eventualis, right? So you have this direct intention, and then what the Supreme Court of Appeal and what Women's Legal Center based its arguments on is that you have a sort of intention where if A foresees the possibility that you did not consent, that the complainant had not consented, right? And he still acts recklessly and unreasonably, right? Then that would be intention. So intention suffices in that way, right? And then really, unlawfulness really speaks to this defense that we have in our law, and it's a common law defense, that there's a defense of mistaken belief in consent, right? So if the accused had believed, even though that belief was mistaken and unreasonable, then it is a defense. But what the Women's Legal Center really has done, and we'll get to that further down in the interview, is that the Women's Legal Center really said that there's this subjective test. Intention is subjective, but there's this element of objectivity, and Brahma will speak more about that.
Okay, great. So I think I'm asking layperson, what is because I do want, and I love that you said that, because that's taking us then into high court.
Yeah.
So he was, so we've given the basic context. He was convicted. It was the magistrate in that first case had said it is rape, and then he appealed. Based on some of the things that you said, I think mistaken belief in consent. And I want to ask, because I'm always like this thing of subjective. So,
Yeah. So look, I mean, like Andrea Joy has spoken about, in our law we have certain tests in terms of proving someone's guilt. And as I said initially, you know, the state has the obligation to prove a matter beyond reasonable doubt. That's in criminal matters, and that's in all criminal matters. And no one can be found guilty of doing something that they didn't intend to do. And that's reason. I mean, that's a good principle of law. It's you know, that speaks to the rule of law, and that speaks to good democratic principles throughout the world where the rule of law is utmost. So there's nothing wrong with the test, that we must have a knowledge that we are committing an offence. Yes, there is that issue of, you know, ignorance of the law is no defence, but there must be an element of understanding that what you are doing is committing an offence. So, and we agree with that. That's certainly not something that we wouldn't agree with. But what happened in the High Court when he went on appeal to the High Court, basically, in our opinion, the High Court effectively actually gave the accused a defense and said that based on the fact that he had performed oral sex and he had implied, well, he believed that she had implied consent by consenting to penetrative sex, by consenting to the oral sex, that how was he to know that she wasn't now consenting to the penetrative sex? So she consented to one sexual act, and now because of the way she hadn't objected to that, she kind of, well, according to him, she didn't say no, even though she had actually previously indicated very clearly to him that she didn't want to engage in penetrative sex. He testified in the lower court, and the higher court found credence or credibility to his statement that he went with the flow because she had consented to the oral sex and hadn't kind of more overtly in any way said no to anything further, which is simply not true. So if we go back to intention, he has to have knowledge of his unlawfulness. Now, to have knowledge of unlawfulness, it is a subjective test, and you have to know that you're breaking the law. But as Andrea Joy referred to a little bit ago, when we talk about intention, there are different forms of intention. Now, he basically, we believe, because of what we call the objective facts around the situation, although it's a subjective test, one has to take into consideration the objective facts. And the objective facts in this case were that they'd had a previous agreement that they wouldn't have sex. Nothing changed. There wasn't at any stage a renegotiation. But the High Court felt that based on her implied or implicit, maybe not explicit, but implicit consent that he had read into the situation, he had believed that she was consenting, even if it was unreasonable. And when we get to the Supreme Court of Appeal, that's what we started arguing, is that basically, although he may have believed that she was consenting because she consented to previous acts, that was, given the consideration of the objective facts, that was not a reasonable conclusion to come to. That he must have foreseen the possibility, given their previous agreement, must have foreseen the possibility that she was not consenting, yet he proceeded recklessly to have penetrative sex with her. So he foresaw the possibility that she wasn't consented, and he proceeded recklessly nonetheless. And that's what we argued. But just to go back to the High Court, the High Court then said, basically they gave him that defense and said basically that he had believed that she was consenting based on the fact that she hadn't done anything extra at that time. And very fortunately, through a lot of negotiations and talking with the NPA, the National Prosecuting Authority, who is the only authority in that situation because it's a criminal case, the NPA cannot appeal a case on the facts. They can appeal a case where they believe that there has been a misdirection or a misunderstanding of the law by a court. And we were very much of that opinion from the very beginning. Once we read that judgment, we were like, wait a minute, this court, the High Court, has misapplied. They have incorrectly applied the proper test of intention. And that's when we go back to what is consent and what is the actual test of intention. And the Latin word for intention is dolus. So that's when we talk about dolus, directus, dolus, indirectus, and dolus eventualis. And people will be familiar with the dolus eventualis terminology from the Pistorius case, where even if you foresee the possibility that something might happen and you proceed recklessly, that is when you can be found guilty. If you don't foresee the possibility, if it's an absurd potential of something, then obviously that would you would be found not guilty. But
can I ask a question?
Yes, of course.
So, like, if you're driving,
there we go,
super fast, and obviously you don't intend to knock anybody, but you know that driving really, really fast is dangerous, and that if somebody were to jump into the road or a kid is going after the ball, you wouldn't be able to stop in time. Right?
There is a possibility in that case that would suffice as dolus eventualis. A lot of if somebody dies, just to say, because if somebody dies, otherwise you would be accused of negligent driving. And I mean, intention is a very difficult concept in law, in the sense that it can be difficult to prove. But if you have consideration, and that's the court, when I say when the court has consideration of all the objective facts around it, what I think it really brings into stark reality is that there is this perceived notion in society that women have to constantly communicate that they do not want to proceed any further when it comes to sexual activity. So it's very difficult, because of how society places these restrictions on women and burden on women. So, okay, I will consent to kissing, or I will consent to oral sex, but as soon as that happens, there is almost this expectation that women must then say, but I'm not going to consent to anything else. And when we get to the Supreme Court of Appeal's judgment, we'll see that the Supreme Court of Appeal, which is an excellent judgment, a fantastically applied judgment in terms of the law and really applying the law to the facts of this matter.
But Baron, can I ask, because we have to go to a
Yes.
break soon.
Sure.
So I want to hold that for after the break. But before we go, I think what I want to, there was one of the things that you said previously about how much this woman actually consented. I remember it really hit me when you listed off. So when you talk about women have to constantly communicate that they don't want to proceed, they had, can you just run through? So they had agreement.
They had an agreement. She'd made it very clear. She actually, the court made a bit of a bigger deal out of this, and we don't think that there necessarily should be extra value placed on someone who is a virgin. And for that reason, one must be extra careful, because that also places a kind of strange burden on women. But in this particular matter, she was a virgin, and she was very clear about the fact that she did not want to have sex. So she communicated that to him. He agreed. He said he wouldn't proceed with having sex with her. There were a number of occasions when she said she would stay over with him that night. She again said to him, that doesn't mean, you cannot read into this that I'm coming home and spending the evening with you, meaning that we're going to have sex. And he agreed again. When they started cuddling, she made it clear again, I don't want to have sex with you. When they had the oral sex, she made it clear that she didn't want to have anything more than that. And I think that's the difficulty, is it almost says to women, you can't enjoy just a little bit of sexual activity, because if you do, then men are going to misinterpret it and want to have full sex, and then you've effectively agreed to it. And the good thing is that we now have a judgment that says no ways. You actually have to establish that the woman is consenting to every particular type of sexual act.
Wow. And I remember, like, one of the things also was that besides on the night, even there was this agreement in place from when they started dating.
Yes.
Right? So there's, like, when you talk about, there's a timeline that shows that she didn't want to have sex at this point ever. Thank you so much for that. So we're going to take a short break, but we'll be back with more after this. Welcome back. You're still watching The Womxn Show, and we have been speaking about the nature of consent in rape cases based on a recent case that went through initially the regional court, was appealed in the High Court, and then made its way all the way to the Supreme Court of Appeal, where the NPA had appealed and the Women's Legal Center appeared as friends of the court, and they're going to explain to us what that means alongside two other organizations. But still with us in studio is Andrea Joy-Joanchis, who is a junior associate at the Women's Legal Center, and Advocate Bronwyn Pillay. So before the break, we were sort of running through the case. We looked at it in the regional court. We looked at the appeal in the High Court, and the conviction was overturned, or I don't know if I'm saying that correctly, but the conviction was overturned in the High Court. And then it was appealed in the Supreme Court of Appeal. And Andrea, you were speaking a lot about the interpretation of consent, and what that means, and how fault is established. And you said things like express, tacit, and implied consent. But I think let's just start by looking at, so the case went to the Supreme Court of Appeal. What happened there?
Go ahead.
Maybe you can take this one.
Okay. Yeah.
Okay.
So basically, when we go to the Supreme Court of Appeal, like I mentioned a little bit earlier, it has to be on a question of law, not fact. And as you mentioned, there were three organizations that joined the matter together with the National Prosecuting Authority against the accused as Friends of the Court. And the role of Friends of the Court is really to provide the court with particular aspects of the law that we believe need to be highlighted. And as the Women's Legal Center, which is an African feminist organization, we focus very much on the application, the correct application of consent. And the test for consent, which we've referred to. And like we said, one does have to have knowledge of when you commit an offense. And really what we focused on was exactly what we were talking about, the objective facts which were surrounding the case. And we are delighted to say that the Supreme Court of Appeal really did hear those arguments. They heard and understood that consent to one type of sexual act does not mean an implied consent to another sexual act. The court went to great lengths to say, if you look at the legislation says that the way that consent is defined is by an agreement. It must be a freely entered into agreement. Now, agreement immediately means that you have to have two parties who are engaging with each other to come to a mutually agreed to solution or outcome. Solution is maybe not the right word, but outcome.
Yeah.
And in this situation, in this case, the facts, and we drew heavily on those. We said, look, the facts are very clear. The objective facts that nobody disputed, that they had this long agreement. I think we must also just be careful that it doesn't necessarily mean that every single case that involves a rape, and because we believe that rape cases can obviously happen when there hasn't been like a long history of a negotiation and a talk and everything. But what the court was saying is that there really has to be some kind of potentially evidentiary burden placed on the accused to be able to show why he believed that she was consenting. And in these circumstances where she had been very clear that she wasn't consenting, the court felt that he had to go the extra step, which was what Andrea Joy was talking about earlier on, that actually he needed to do more than just, and these were his own words, he went with the flow. Those were his own words when he testified. So he actually conceded that based on her consent to the oral sex, he kind of went with the flow. And the court said, no ways. In terms of the definition of rape, you actually have to establish consent for every single sexual act that is performed, that actually goes on between the two people. And the other really, really powerful message that the court sent, which not based on the facts of this particular matter, but I think it's fantastic that they commented on it, was that even if you do, as a woman, enter into a consensual, penetrative sexual act with someone, you can withdraw that consent at any stage, and it must be respected. And if you withdraw your consent in any way, either through communicating with it, indicating that you're being hurt, indicating that you don't want to continue, pushing someone away, basically disengaging with the whole sexual act, that constitutes a lack of consent and would then move into a sexual violation or a sexual offense. And the court was very clear about that, and I think that that's a very exciting thing that they commented on. And basically saying that it was in this particular case, that it actually was disingenuous on the part of the accused, that he said that he relied on this implied consent, this kind of tacit implied consent that she had given based on her body language.
And cues and,
Absolutely. And going back to exactly where you said in the beginning, this kind of fallacy of, well, women often kind of play a little bit hard to get or they resist a bit, but in the end what they actually mean is that they do want to, but they've got to come across as having a kind of moral to. So that's why women behave in this particular way. Not actually hearing that, no, women are not wanting to behave in that way. They actually are not consenting to that. And I think a lot of this also has to do with the fact of not recognizing agency of women to be sexual and to engage sexually with people. That why is it that as soon as a woman engages sexually, that means that she wants to have sex? What we're not allowing is for women of whatever age to consent and enjoy and engage actively as a sexual being, but may not necessarily want to have penetrative sex. And that was what was also problematic about the High Court, is that the High Court said she engaged, she was an active participant, etc. It was almost like she was labeled in a negative way. Well, you're an active sexual participant, therefore you must have consented to everything. And what it really does do is that it brings in, which is actually incorrect in our law, this requirement or this element of resistance. Unless we see overt resistance, well, then you're consenting.
Yeah, and it sounds resonates very much in the early, very, very, back in history for it to be considered rape, you need to have. So, I mean, we've been here actually before speaking about the notion of real rape, right? So what is real rape? And
I think that is exactly what the judgment does, hey? Because after the High Court judgment had come out, what had happened was it was all around, but foreplay leads to sex.
Yes.
Right? And what the judgment really says is that no, consent to one sexual act, and that's what the act actually says in legislation. A single sexual act, right, does not mean consent to penetrative sex.
And that's what I wanted to say, because you came in and you gave us like this really great rundown. There's a Sexual Offences Act. It defines consent. How does this, and I mean for us lay people, for us at home, what does this change for us in relation to, or how does it change the way we need to think about it? Like, I'm just like, what is the message out there now?
I think for women, it is knowing that this judgment exists and that consent is established, intention, all of these very complicated legal terms are established, but to know that this is what consent looks like. Consent to one sexual act does not mean consent to penetration. And so in that way, women can actually say, no, but I do know my rights. I know my rights. I know what the law says about consent, and that it's not, the onus isn't always on me to have to say, you know, yes, we protect ourselves and we feel the need to protect ourselves to say, no, I'm saying no. And in this case, she said no. And even when the SCA wrote the judgment, what happened was the SCA actually said, even if she withdraws consent, right, at any point, then it means consent is no longer there. So, yeah.
I think what is problematic, and we've seen this, and the kind of backlash from a lot of people, particularly on social media, when people can hide behind their pseudonyms and all the rest of it. That, you know, I've seen comments unfortunately from a lot of men saying, well, what did she expect? You know, you kind of engage in this kind of thing. It's the loaded gun. It's
I was going to say, the loaded gun was the one that
how can you do this to men? They're sexually aroused. You know, it's unfair to like lead men down the garden path. And you know, what did she expect? Where did she think this was going? You know,
she went to sleep over.
Yeah,
right?
She went to sleep over, and she engaged with him in oral sex consensually. What did she expect? And I think that's exactly the point: is why can't women expect to sleep over at night and have oral sex, and that's it? Why can't they expect that? And why is it that as soon as women engage sexually, that means that they want to have full-on penetrative sex? And I think what's been encouraging, the flip side of the backlash from a lot of men has been, you know, how can you leave men in the lurch like this, you know, etc. Is that what I've been encouraged by is other men coming forward, and unfortunately I think it has to be a lot of the time other men coming forward and saying, no, that's rubbish. Actually, we do have to respect that. And actually as men, sometimes we don't want to have penetrative sex either. We also want to engage in a whole lot of foreplay. And that maybe we don't want to do that. But there's this pressure of like other men, well, if you didn't have full-on sex, well, then it was a waste of time, you know, whatever you were doing. And I think that's the kind of discussion you say, like, well, how does this go forward? This is a public debate. It must be spoken about. It must be spoken about outside of courtrooms. It must be spoken about in communities, in families. That consent is a fundamental thing to establish. And this thing about it being a passion killer, and that it's really not a big deal to establish someone's consent. You know, it's not like anyone's asking for written contracts here. And that's when it's ridiculed. And it's like, oh, what do you want me to do? Like sign on the dotted line that you're consenting. I think that's ridiculing it, and it's undermining women's, and we speak about women's real lived experiences of engaging. Why can't women be sexual without saying, actually, well, what I'm consenting to is everything? I actually want to engage as a sexual being, but not necessarily, you know, all the way, which is, and I think it's also an unfair thing to place on men to say, well, that's actually all that men want. Because I think that there are plenty of men who are stepping up and saying, actually, no, We also want intimacy, but not necessarily have sex.
And so, and I love that you spoke about that, because also what I thought was really important when I was reading the judgment and was considering like what this means for society is like, what is the, and whether it's possible for us to be very clear here. If we were speaking to men, and we do have a really good male audience out there actually, what is the message there? I mean, what is something that they can take from it? Because I think this is really important.
I think the message is that you need to respect. You need to respect that the person you're engaging with has choices and can change her mind, just like you can as a man. Everyone changes their mind given a situation that suddenly you don't feel comfortable. And I think it's really important to go in there as a responsible human being, as a responsible adult, and say, what am I doing, and am I establishing that this person I'm with is comfortable with what is happening?
And that, I think I was respectful, but actually it's a crime.
Yes, and if you don't establish that that person is consenting, it is a crime. You are committing a criminal offence. And we need to take that far more seriously. You know, there are so many women who don't come forward because of these kind of cases. And I think, you know, credence must be given to the complainant in this matter. She has been subjected to this for 6 years. This case has been going on in the courts. And, you know, just really to say, you know, well done to her for kind of sticking with it. And it doesn't change what happened to her, but I really hope that she feels some vindication, that her experience was real and that she did not consent to this, and that has been recognized by the Supreme Court of Appeal, which really is, you know, second to the Constitutional Court, but on these matters really is considered to be the highest court in the country.
I wanted to actually ask about that, because I can imagine 6 years, and we know that rape cases in general take very long, that she was able to sort of stick with this, especially after the High Court ruling.
And an overturned judgment.
Yes.
Yeah.
So can I ask then, after the High Court ruling, did he then go free?
Yes, he was released.
He was acquitted.
So basically, yes, exactly like he was acquitted. His conviction was set aside. So he was released. He actually was already serving his sentence from the regional court, and he was set free. So what has now been ordered by the Supreme Court of Appeal is that it must immediately, the sentence must be reinstituted. It must be reinstituted. And that was a sentence of imprisonment. So he will go back to jail.
So what's fascinating for me also is that, and I think I mentioned this to you earlier, that our perception on the ground of law, and maybe that is also why, perhaps I can think what would lead people to, or women not to report this thing. We think the law is sort of cast in stone, and that this is what's legal and this is what's illegal. And yet what this case shows us as it travels through these three courts is that the law is very, very fluid. I wanted to just ask for more clarification on when you say interpretation, because for me, it's very confusing when I think about, here was this conviction, and someone else or some other institution can just say it means another thing.
Well, I think that's the issue of law, is that it's an alive thing, you know. Just because it's like anything, you know, you could read a book and I could read a book and we could get two different things out of it.
Yeah.
It's human. We draft laws with the best possible intention of being clear and of protecting people. But there's always an interpretation of law. Law is complex because of that. And that's why we have a very good system of appeal, that we allow the possibility that mistakes are made by lower courts. And the theory is that we have more and more experienced judges and judicial officers as we go up the kind of hierarchy of courts, and that when they have the opportunity to apply their minds because they have more experience and they have more, and then they also get the input of organizations and civil society organizations and women's organizations like the Women's Legal Center, to start hearing the voices of women to actually give context to a particular thing. And I think what we also need to, you know, the law is quite strange. Sometimes it plays catch up to what society, we need laws to catch up with how society develops. But I think in this situation, the law is actually is leading the way. It's the beacon of hope. It's saying, yes, that's what the law says, so now we're going to clarify exactly what the law means. We can see what it says on paper, but this is what it means practically. And that's why it's so important to bring those lived realities of women's experiences to the courts so that they can actually consider this is the reality of how the law plays out. Academics can sit and say things like, yes, there's a defense of mistaken belief in consent, and it's a reasonable, even if it's an unreasonable belief. But look at the practicalities of the cases where these defenses are used. And I've yet to see one that actually, if you look at the objective facts, that one could actually genuinely get a defense like that that could work, that would stick and result in an acquittal. Academically, yes, but practically, no.
Yeah, that's very, very interesting. And yeah, I just also wanted to ask, and I saw you nodding when we were speaking about the complainant, and I know that the Women's Legal Center works with cases of sexual assault all the time, and whether you had any thoughts on, for me, I just imagined her sitting there and so for me, I imagined her sitting there, having this story of just even having consented to oral sex out there about her, and people know it. It's so sensitive. And is victim blaming a thing that you see often in these types of cases that move through the Women's Legal Center?
Not just through the cases that move through, but in our communities, in our homes, in our families. The question, just in this case, but why did she go?
Yeah.
To why did you sleep over? Why, when he pulled off her pants, did she not run? Or why were you there? Why were you walking around late? That it's all consequences of societal norms and socialization, and it's very rife in our communities, in our families. Yeah.
So then, sorry, we just have like 3 minutes left. And so then I just want to ask, from the women who are on the front line of dealing with these types of cases and witness, almost direct witness to this victim blaming, not just from everyone, but like you're saying, from the families, because they're usually involved, right, in the case, they're there and so forth. Maybe this is too big of a question, but is there any advice that you can give women? We know that in our audiences, women are sitting and going through these things. I always try to not ignore that you are facing backlash as you move through the system, and you are facing the court of public opinion and judgments and so forth. Do you have, I don't know, just a word or anything that you can give to them?
Yeah. I think one of the things on quite a practical level, and I think this is where, again, kudos must be given to, say, the National Prosecuting Authority, who have established Tutuzela care centres, who the police have specialised units in terms of dealing with sexual offences, the FCS units. We have specialised sexual offences courts. So I think there's a real recognition on the part of government that we do need specialised services, and specialised services must be provided, particularly around sexual violence. So I think the message out there is certainly we do have cases that can be dealt with by people who know what they're doing, and that's encouraging. Unfortunately, it's not a perfect system by a long shot. We still have very, very low conviction rates. So what I really would suggest is that if people find themselves in situations like this, to seek help, first of all, from organizations that are equipped to deal with it. It's very important to deal with the psychosocial aspects in terms of having support systems, having counseling, to be able to talk through these things, to have that kind of support, and to help you negotiate the criminal justice system, which is a difficult system.
Yeah.
It helps to have either family members, friends, organizations that provide that kind of assistance. And there are organizations.
Thank you so much. And we are out of time. I just want to thank you so much for coming on and for discussing this with us.
Great. Thanks very much.
We are going to take a short break, but we'll be back with more after this. Welcome back. You're still watching The Womxn Show, and we've been having a very interesting and informative conversation about the issue of consent in rape cases. Now, we want to acknowledge that it is very, very difficult to report a rape. Survivors are often worried about what is going to happen if they approach the police station or they go straight to the hospital. Tutuzela care centers were set up as a sort of one-stop shop for survivors of abuse, and you can approach them directly. They are based on the premises of many hospitals. A short video was made to show what services you can expect if you approach a Tutuzela care center, and we're going to play that short video to illustrate that. Let's have a look.
South Africa is considered to be the rape capital of the world, with 10,818 rape cases reported in the first quarter of 2022. The rate at which women are killed by intimate partners in this country is 5 times higher than the global average. The Heideveld Thuthuzela Care Centre stands as a beacon of hope on the Cape Flats, serving as one of South Africa's one-stop facilities dedicated to providing comprehensive support for victims of rape and gender-based violence.
The concept is that it is a one-stop center for people that have been sexually violated.
3 months shy of my 16th birthday, I was gang raped and my best friend murdered. And as a survivor of such a heinous act or rape, I was not afforded the opportunity to receive services such as this.
Operating within the Heideveld Community Health Centre, the TCC plays a pivotal role in transforming the experiences of survivors by offering social, psychological, medical, and legal services.
So on arrival, a client will arrive at this facility. There's a reception desk, and at the reception desk there will be someone from Rape Crisis that will receive them and will then inform the first responder that we have a client that has arrived.
My role as the first responder is to meet the client, greet the client, and also do containment with the client.
That point of in between the incident and the medical examination is to contain the person so that the person is more relaxed and more prepared to know what is about to happen to them.
So then the third person they will see is then our nurse. They will do a HIV test, a rapid test, they'll do a syphilis rapid test and a pregnancy test if it indicated. They also take the height and the weight of the patient, and they do other basic observations like the pulse, blood pressure, temperature, so on.
From there, a client goes to the forensic examiner where the forensic examination takes place.
When the patient comes, she comes with a crime kit. When she comes with the police, I will use the crime kit, first take the history of what happened.
And that notes will stay in the folder of the hospital. It does not go to court.
So I will do the examination and take all the relevant swabs that I need to take from the patient, and then close the kit, and then call the investigating officer who will be outside.
After that, a client will be offered the opportunity to shower, and then also if clothing has been taken, they will also provide them with a comfort pack.
In the comfort pack, we've got soap and face cloth.
You can find a toy in there, a suitable toy for which, whether it's a boy or a girl, and there will be resource material in that they could use once they leave the centre.
By then, SAPS would have been informed, and the FCS unit from SAPS will come out and do the statement taking. The victim assistant officer is the last person to see the client.
We know that when a survivor comes through our centre and through our doors, that a journey doesn't end here, and this is only the start of a journey. And also we're a point of contact for the survivor, because going through the criminal justice system can be very scary, it can be very intimidating. That's why we have a database where we feed information to the court, and the court feeds information back to the Thuthuzela Care Centre. We are that link, we link our survivors to the relevant service providers. So that is our role on a daily basis, to make sure that the survivor is supported holistically.
What is really shocking about, these facilities is the number of children that we see. So this is why at this facility we made specific provision for a kids' room, so that kids, while they are waiting for services to be provided, that they can sit in the kids' room and play with toys.
Our victims know that they can come back anytime if they want help, or if they're not sure, if something happened, if they want advice. We do not turn people away.
When you know that you are helping someone at the end of the day, you are putting a smile to someone who came crying. It's our goal, because I need to know that I've restored that person's dignity. I've made that person see beyond what she came here for, that there is still a purpose to live.
Are we supposed to be excited about the Rape Care Centre? I guess not. However, I know that it's for It's for the survivors, this is a huge plus. So thank you to Tuzela Care Centre and all the stakeholders and everybody that was involved in the design and implementation of this centre.
This project would not have been possible without the careful collaboration from all stakeholders with the collective vision shared to help gender-based violence victims.
That was a short video showing the services by the Thuthuzela Care Centre. And that is all we have for today. Thank you for joining us. I'm Lenina Rasool. Goodbye.